Ladies and gentlemen of the jury, we have arrived at the point in this trial where you have to decide, based on the evidence that you have heard, whether or not the defendant is guilty or not guilty. I suspect you probably think that I'm going to say that the prosecution has not proved their case against the defendant, the case that was put forward wasn't strong enough for the defendant, and so on and so forth. Well, I'm not going to say that, at least not yet. You see, I have to put things in its proper context and circumstance for you. So you're going to remember those two words, context and circumstance. I'm going to give you a story, and it's a true story, I promise. It's a very true story. Many years ago, when I was just a little girl, just about 8 years old, I had this colorful lollipop. This was like a rainbow. It was very pretty. And I'd had one before, so I knew it tasted really good. And I was showing off that I had this lollipop, and there was this guy from the class that I was in. He was a bit of a troublemaker, and he was trying to get that lollipop from me. And of course, I was not going to give up my lollipop, no way. I paid money for that. I wasn't going to give it to him. And he tried to take it from me, and somehow we ended up in a bit of a scuffle. And this was during recess, so everyone was around, everyone could see. Somehow, word got to my older brother that your sister was fighting, a boy was beating your sister. And out of nowhere came my brother. And he just took over that fight, and he just put that boy down. Of course, when we got home, and my mother heard about the fight, she wasn't very pleased about it. Because she had this thing, she's not raising hooligans. And where I am from, what your mother says goes. You don't argue. There's no room for negotiation. You obey. If you don't obey, there are going to be consequences. So my mother was beating my brother, and every time she lashed him, she was saying, I didn't send you to school to fight. I'm working hard. How dare you disobey me? And she was going on and on and on. At one point in time, she said to him, all you had to do was not fight. You did not have to fight. And my brother said, I did have to fight, Mom. He was hitting Susan. When she heard that, suddenly, all her morals went out of the window. He was hitting you? And she turned to me and she asked me a question. And I explained to her what happened. And at that point in time, the reason why my brother was fighting was put in its proper context for her, and the circumstances that led to the fight were explained to her at that point in time. And of course, she's coming to the school tomorrow. Did that boy get suspended? Who are his parents? The story changed. The narrative changed. Because the context and the circumstances had been explained to her. Now let's apply that particular train of thought to this situation with Mr. Foster. Mr. Foster was in the pub, exited the pub, and saw his friend in what he perceived to have been imminent danger. He didn't have time to think about what he was going to do. He just acted. Context and circumstance. Now I'm going to tell you what the prosecution did not do. They made an allegation against Mr. Foster that what he did in terms of striking Mr. Brandt was unlawful. But they have not disproved the defense that he put forward. From day one, Mr. Foster argued consistently that he was acting in defense of his friend. His account never changed. He never wavered in what he said. He was consistent throughout. Now let's see what the prosecution did. And please remember those two words, context and circumstance. The prosecution had several witnesses testifying during the trial. The victim himself, Mr. Brandt, admitted on cross-examination that Mr. Foster was not involved in the fight until after he had the knife in his hand, and that Mr. Foster only struck him once. That's not different from what Mr. Foster had said from the beginning. Ms. Dawn Smith, who allegedly, she had a very good view, a bird's eye view of the whole account. She could not say with any certainty that Mr. Foster had struck Mr. Brandt more than once. And you know why? Because he didn't strike him more than once. He only delivered one blow. P.C. Fowler, he said that when he apprehended Mr. Foster, he was shouting, "That bastard," and he was referring to the victim, "was going for my mates." So obviously, you can see some sort of proof there that he was trying to defend his friend. P.C. Baker, he gave evidence that Mr. Foster approached the scene of the fight later, and that it took a matter of seconds to deliver one blow. Did you hear that? One single blow. None of the prosecution witnesses have given any evidence that contradicts anything that Mr. Foster said. The prosecution have not sought, they've called all these witnesses, and as far as we are concerned, all they have succeeded in doing is basically backing up what Mr. Foster has been saying from the beginning. He was defending his friend, and he only struck him once over the head with the bottle. Now, I don't know about you, but if I'm going to hit someone and I intend to cause them some serious harm, I'm not going to hit them one time. Mr. Foster had that bottle and he struck him once. He could have hit him repeatedly. He could have broken the bottle on the ground and then struck him with it to cause more harm, but he didn't do that. He took the bottle, hit him once, because his object was basically to stop him from harming his friend. Now, you are in a very privileged position, members of the jury. You can sit and you can think, if I was in that situation, maybe I would have shouted or called for help or something. But guess what? Mr. Foster did not have the luxury of time. He didn't have the luxury of clear and practical thinking. He had mere seconds to respond, and respond he did. One blow to the head of the victim, and that was it. Where in that can you say that he intended to harm him? Please, think about it. Where? Remember those two words, context and circumstances. Now, the prosecution, to their credit, and I use the word credit, very, very warily, they did what they were supposed to do. The police apprehended someone, police charged this person, and of course it's the job of the prosecution to prosecute that individual. So they did what the textbook said they were supposed to do. But you know what they didn't do? They didn't read the manual a little more. Because that same textbook would have indicated to them that if you're going to bring a case against someone, you must prove it. You must cover all the circumstances. You must put it in its right context, and you must prove it. They didn't do that. So you know what they have in their arsenal? The fact that Mr. Foster has a previous conviction. Yes, they said. He's done this before, they said. We're going to get it admitted into evidence, they said. We're going to let the jury see that he's prone to fighting after football matches, they said. He's a football hooligan, they said. But let's put the previous conviction that Mr. Foster has in its context and in its proper circumstance. Well, for one thing, we don't know what the circumstances were 9 years ago when he was convicted. We don't know the parties. We don't know how the incident unfolded. We don't know anything. All we know, the jury at that time thought he was guilty of the offense and he was convicted. But we know today, in this particular circumstance, we know what happened. We know there was a fight. We know he was trying to defend his friend from getting harmed. And we know that his response, the one blow, was proportionate. It didn't show that he had an intention to seriously harm the victim. Now, with regards to this particular previous conviction, you will appreciate that this happened approximately 9 years ago. And again, you don't know the circumstances. But here's what we do know. 9 years ago, Mr. Foster really had nothing to lose. He wasn't a parent. He didn't have a sickly child. But today, 9 years later, he has a child. He's a parent. He has responsibilities. So he has a lot to lose today. So maybe 9 years ago, maybe that conviction was warranted. I don't know. Guess what? It doesn't matter. But today, you have the context and you have the circumstances. So you understand that even if there is a previous conviction against the defendant, you know what the context and the circumstances are today. You don't know what they were 9 years ago. So we've come full circle. As I said, the prosecution brought a textbook cookie cutter case. They did what they were supposed to do, but they have not. And if you are true, if you are listening, if you've been paying attention, if you've been listening, if you are true to yourself, you would recognize that they have not disproved his defense that he was defending another person. You've heard all the evidence from both sides. The incident has been laid out. I've just put it in its proper context with all the circumstances for you. And you still, I think if you analyze everything, if you distilled everything, if you threw out the things that were irrelevant, you would come to the undeniable conclusion that the prosecution has not disproved the defense put forward by Mr. Foster, and as a result of that, there is no way that you can convict him because you know the context and you know